It's the appointed time. We have a quorum. So I call the meeting to order. Welcome, everyone. So this is a meeting of the Subcommittee on two items of subsidiary legislation made under the Safeguarding National Security Ordinance. This is our second meeting. So we resume our scrutiny of legal notice number 77. So we will now open the floor to questions. We first hear from Dr. Kennedy Wong. So we're in part 2. This is about the National Security Committee giving effect to opinion. Now we have some general provisions. Paragraph 2 here says that there are opinions to be provided by the National Security Committee. In English, it reads opinion. So my question for the government is this. The OSOS has the power to oversee and guide the work of the HASAR. So that sounds like broad powers, but here it says opinion. Why not use recommendation instead? Or can we use some more solid terms like directions or instructions? So why not use those terms instead? Drafting team from the DOJ, Department of Justice. Thank you. Now in choosing the word, now we have in mind Article 49, Paragraph 1. It's about overseeing and providing guidance. So opinion, according to dictionaries, is that it's opinion from, say, a competent authority, and that reflect the meaning under the national security law. So this may not be a formal document. So that's our message here. Thank you. Chairman, I want to make this point. The mainland, in drafting laws, uses terms like opinion and recommendations very often. So why not say opinion or recommendation here? I believe the national security law was first drafted in Chinese, so why not follow the usual practice in Chinese? Drafting team from the DOJ. We believe the term opinion covers the meaning when it comes to overseeing or providing guidance. As for the term recommendation, it does not carry any mandatory meaning in itself. So within the context of overseeing and providing guidance, I think opinion is good enough. Sorry, Chairman, I just looked up an online dictionary. Opinion is something that people can adopt or not. But when a recommendation comes along, that sounds like something people are more likely to have to follow. So I believe that's an opinion from the member, right? So we're looking at the English translation of the NSL. There is the term proposal. Indeed. But that does not sound as formal as the term opinion. So I believe that's a proposal or an opinion from Dr. Kennedy Wong. So I will accept that opinion. So let's move on. Deputy Secretary. So we now come to Part 3, Section 3. The government to provide assistance for the OSNS in the context of Article 55 of the Hong Kong National Security Law. So when a director or a deputy director of the OSNS approves the OSNS to take certain measures. So this is before we invoke Article 55, says steps are taken at this point. Government departments and public servants must, on the request of the OSNS, provide all necessary and reasonable assistance, facilitation, support, backing, and protection in a timely way. Thank you. Questions? Mr. Jeffrey Lam. Sections 3, 4, and 10 mention that public servants have to provide assistance to the OSNS in accordance with the law. So I'm looking for clarification here. What does in accordance with the law mean? What does the law here mean? Law officer. Thank you. By in accordance with the law here, we're talking about in accordance with Hong Kong's laws, and that means all ordinances, common law, the basic law, and the Hong Kong Bill of Rights. All those are included within the meaning of the law here. Follow-up questions? Now, at the first session earlier today, I believe we're talking about law not just in the sense of the NSL, but also other laws of Hong Kong. I thank the government for the clarification. Mr. Kitson Yang. The drafting here says any department or agency of the government or any public servant. Why not say any agency? You just simply say agency here. Under the government, there are many agencies. You have the Hong Kong Monetary Authority, the Urban Renewal Authority. The government appoints the chief executive to the URA and the board of directors. Does the URA count as an agency? Is there any special reason we're saying agency here? Thank you. When we say any department or agency of the government or any public servant, the wording here is in line with Section 110 of the SNSO, or Safeguarding National Security Ordinance. So we are modeling the drafting on Section 110 of the SNSO. So it says any department or agency of the government. That's one phrase, and or any public servant. That's another phrase. You don't have to repeat the word any before every word. Any follow-up? So by agency, what do we mean? There are many different bodies under the government. You have HKMA, the URA. The Hong Kong's Housing Society also has something to do with the government. So do they count, or are we simply talking about bodies where the government appoints its officers? So where do we draw the line? I'm looking for clarity here. Law officer. Now, by department or agency, as we said this morning, we're talking about bodies under the control of the government. So you have the civil service, the department, say the law enforcement agencies, and we all know what law enforcement agencies are, say the police, the immigration. So we're talking about bodies within the government. So that means agency here does not include the example cited by the member. Mr. Tony Tse. So there was a clarification by agency. We're talking about bodies within the government. Now, when we were looking at the Safeguarding National Security Bill, there was a definition for public officer. And here it says public servant. So here, public servant now we know what department means. People working under a department count as public servants. Employees of government agencies, do they also count as public servants? Say you have the hospital authority. Some people there are public servants, but other workers are hired by the HA on their own. So can we have some clarity here? Because we have to know Who will be responsible for what? At the earlier meeting today, in determining whether circumstances related to Article 55 of the NSL arise, the government can also raise the matter for the OSNS to consider. Here, the drafting says director or any deputy director of the OSNS. There is just one deputy director. Do we have just one deputy director? Who will take the question, please? Secretary for Security. I will take the question about director versus deputy director. So the number of deputy directors is a matter that is an internal matter for the OSNS. That's not the focus. We're simply saying someone at the rank of deputy director signs a document, and that document will have the effect. Now, the law officer will take the other question. On the point about public servant, as we explained this morning, so we follow the definition set out under the Interpretation and General Clauses Ordinance. We also have to bear in mind the precedents, meaning the court rulings. This is about the control. And we also have to consider a range of factors. So the employer matters, who can appoint this person, who can dismiss the person, the nature of this officer's day-to-day work, whose instructions this officer takes. So we have to approach the matter on a case-by-case basis. We want to cover civil servants and contract workers. As for people outside that scope, the term public servant does not apply, but that is not to say that those people have no responsibility at all. Now, for Section 8, Subsection 3 of the SNSO says when the law confers a function on a certain person, that function is to be read as including the duty to safeguard national security. So everyone has the responsibility. So in a broader sense, every Chinese national has the duty to safeguard national security. And our law also says that everyone has to safeguard national security. Mr. Gary Chen. I'm looking at Section 3. Say when the OSNS decides to take action under Article 55 of the NSL, approval of the director or the deputy director is needed. Why are we phrasing the provision like this? Are we saying that the matter is serious and that's why we need someone senior to give approval? Is that the point? And when a director or deputy director issues such a document or gives the approval, so how will the SCR government work with the OSNS to make sure that everyone is aware that a director or a deputy director has given the approval? Will there be a way for the public to tell that such an approval has been given? You have to find a way to let civil servants know. Will there be some kind of internal channel for people to learn that such an approval has been given? Secretary for Security. The law here says we need an approval from the director or deputy director of the OSNS for a reason. As we said, Article 55 of the NSL applies in rare and serious cases. In those cases, the OSNS will have to step in. It will be a major incident. That's why we need the director or deputy director of the OSNS to look at the circumstances and make a decision. And then we follow up, we give support. After all, Article 55 applies to very serious matters. The law does not require that the document should be made public. We don't see such need either. Those documents may cover content related to the matter. So those documents will not be made public.
It says that the OSNS has to make a request. So apart from signing, the OSNS have to make a request. Am I right? Yes. Ms. Carmen Khan. Thank you, Chairman. I have a comment. I hope that when the administration proceeds with the clause-by-clause scrutiny later on, tell us about the reasoning behind all the provisions, because Article 55 covers very rare circumstances. So I think that there should be a procedures for us to ascertain whether a circumstance is a Article 55 circumstance. So I'd like to know more about the decision-making process. And because the decision of ascertaining whether a circumstance is Article 55(1), we need the director or deputy director to approve the OSNS to take measures. That's my comment. I hope that the administration will explain why we need such a provision. Any response? I think that we have already replied to the question. There has to be a request, and then the director or deputy director have to sign the approval document. Any other questions? Mrs. Regina Ip. Thank you. I'd like to ask about Section 4. I have no questions about Section 3. If there's no other questions, let's proceed to the next section. Thank you, Chairman. Section 4. As mentioned by Ms. Carmen Khan, government have to provide assistance for OSNS to exercise jurisdiction pursuant to Article 55 of the Hong Kong National Security Law, as Article 55 circumstances are rare ones and they are major and have impact extensively. So if the OSNS in exercising jurisdiction pursuant to Article 55 of the National Security Law decides to take certain measures in accordance with the law or executes a legal instrument, any department or agency of the government or any public servant must, similar to Section 3, on request of the OSNS, provide for the OSNS taking the measures or the OSNS is executing the instrument all necessary and reasonable assistance, facilitation, support, backing, and protection in accordance with the law and in a timely manner. So this is when the OSNS has jurisdiction over a circumstance ascertained as Article 55(1). Mrs. Regina Ip. Thank you, Chairman. So if the OSNS is to exercise jurisdiction over a Article 55 circumstance, so two teams have to take enforcement action against the case. One would be the OSNS to implement legal instrument. Also, the government departments and agencies will also have to assist the OSNS in the due execution of the duty. Is my understanding correct? Yes. OSNS has to implement the illegal instrument. They can also request assistance from the government. Any other questions? If not, please proceed to the next section. Thank you, Chairman. Section 5, offense of failing to comply with legal instrument. As I mentioned, in accordance with Article 55, the legal instrument signed by the OSNS has legal status in Hong Kong, so everyone has to abide by it. If there is any individual, organizations, or corporations that refuse to comply with the legal instrument, there will be severe consequences, because that will affect the OSNS in the execution of their duty under Article 55. So any person who fails to comply with a legal instrument served on the person will commit an offense. There are 3 subsections to this section. Anyone who fails to comply with the legal instrument will commit an offense and is liable on conviction on indictment to a fine of $500,000 and imprisonment for 7 years. Subsection 2. Someone charged with an offense under subsection 1 if they can establish that at the time of the alleged offense, they had a reasonable excuse for failing to comply with the legal instrument, then they have a defense. Subsection 3 states that a person is taken to have established a matter that needs to be established for a defense if there is sufficient evidence to raise an issue with respect to that matter and the contrary is not proved by the prosecution beyond reasonable doubt. Thank you. Questions? Mr. Jeffrey Lam. Chairman, regarding 5(1), it says that the penalty is a fine of $500,000. And the fine is set out in many other provisions as well. I wonder why penalty is not set out under Safeguarding National Security Ordinance. However, penalty is set out for offenses under the subsidiary legislation. The drafting team, please. Chairman, I will take the question. Mr. Lan. Thank you, Mr. Lam, for the question. As Mr. Lam has observed, in the principal ordinance, there are many offenses where the penalty is not set out. Sometimes only jail term is stated as the penalty. However, according to other ordinances such as the Section 113 of the Criminal Procedures Ordinance and the Magistrates Ordinance, Section 95, it says that if jail term is involved in an offense, the court has the power to hand down a fine in replacement of a jail term or hand down a penalty of imprisonment term plus fine. So we don't have to set out the maximum fine or imprisonment term explicitly in all provisions. The reason why we set out the level of fine and jail term in all of the offenses is because under Section 112(2), it says that the Chief Executive and Council, when they lay down the subsidiary legislation, is empowered to set out the level of penalty and fine. So for the sake of clarity, we prefer to set out very clearly the maximum fine and imprisonment term. In some of the provisions, we have reduced the level of fine and imprisonment for some of the offenses compared to relevant offenses in other principal ordinances. Thank you. Is it because the principal ordinance set a scope of the penalty that you can hand down for the subsidiary legislation? Yes, that's correct. If we don't lay down the level of fine in the subsidiary legislation, then people wouldn't know if a fine would be involved for a certain offense. So for the sake of clarity, we clearly set that out in the provisions. Mr. Chan Hak-ken, thank you. For a regular member of the public, how can they verify the validity of a legal instrument signed by OSNS? We have a lot of online scams and legal scams, or telescam rather. If someone says that you will be fined a certain amount if you don't comply with the quote-unquote legal instrument of the OSNS, the person may have to find someone to confirm. They may make a call to the OSNS or the police. Will they violate Section 8 of the subsidiary legislation, that is, disclosing the action of OSNS? How can a regular member of the public make sure that they have actually received a true legal instrument signed by the OSNS? How can we prevent people from falling victim to scams? Secretary. if you suspect any false legal instrument being sent to you, you should make a report to the police. Actually, someone purports to be from legal or law enforcement agencies all the time. When that happens, that will constitute a defense. Of course, we have to look at the circumstances of the case. If the police confirms with you that's a legal instrument signed by the OSNS, you still refuses to believe that, that would not constitute a defense. An act of verifying the legal instrument would constitute a reasonable excuse. Mr. Holden Chow. Thank you, Chairman. Section 5, bracket 3 says that as long as there is a sufficient evidence to raise an issue with respect to the relevant matter and the contrary is not proved by the prosecution beyond reasonable doubt, then a person is taken to have established a matters that needs to be established for a defense. For criminal offenses, they have to be proved beyond reasonable doubt. However, for Section 8, disclosing measures being taken or investigation being conducted by OSNS, no legal defense is provided for. Why is the drafting different between these two provisions? Mr. Leung. Thank you. It has to do with the criminal elements and the burden of proof for this offense. If you don't mind, I can explain about that here. Please do. Thank you. Mr. Chow is correct. Under subsection 3 of section 5, we provide for a defense with the evidential burden. A person being charged may have many different reasonable excuses. In order to make it easy for the person being charged to raise a defense, such that the principle of innocent until proven guilty would not be overturned. That's why the burden of proof is still with the prosecution. They have to prove beyond reasonable doubt that the defendant has no reasonable excuse to not comply with the legal instrument. For Section 8, the situation is quite different. We have not included the evidential burden here. That's because Section 8 is about disclosing measures being taken or investigation being conducted by OSNS. If the OSNS is already taking measures or investigating a case that endanger national security law under Article 55, the consequence of disclosing such measures or investigation would be very severe. So if you know or suspect that the OSNS is investigating a case and you intentionally disclose the measures or investigation, then that's a criminal act without question. So the burden of proof should then fall on the defendant. That's why under Section 8, we have not included the provisions on evidential burden.
Chairman, I have overrun. Can I ask again, or should I wait for the next time? Sure, I will press the button and ask when I get to speak next. Mr. Kitson Yang, I'm looking at Section 5, subsection 1. So, a person who fails to comply with a legal instrument served on the person commits an offense, and then Section 2 says it's a defense for someone to raise a reasonable excuse. What if this person claims they have not received the instrument? Does that count as a reasonable excuse? Secretary, it depends on the circumstances. Say the instrument is on your desk, you have it in your hand. You cannot call that a reasonable excuse by saying you haven't received it. Now, for anyone claiming they have not received the instrument, we will have to look at the circumstances before we can tell whether that counts as a reasonable excuse. Mr. Tony Tse, I'm looking at subsections 2 and 3 under section 5, and they are defenses to the offense under subsection 1. So I'm wondering, so someone is arrested, but then we haven't come to the point of prosecution yet. How do we safeguard the rights of this arrested person in the meantime? So it's sometime between arrest and prosecution. Secretary, so we're talking about the period for the investigation. So an investigation is still going on in this case. So there's a threshold under subsection 3 for prosecution. Chairman, my question is, when someone is arrested, so between arrest and prosecution, that's the investigation. That's when you can raise your reasonable excuse. If you have raised the excuse, then prosecution shouldn't even follow. But if we're not satisfied with the excuse, and we don't think the excuse is reasonable, then we prosecute the person. And then you can raise that reasonable excuse at court. Ms. Carmen Khan. So here we're talking about a case where Article 55 has been invoked, and this will be a rare occasion. Now let's look at Article 57 of the NSL. This is about receiving legal instruments. Those instruments have legal force in Hong Kong, and that's Article 57. Okay, the instrument has legal force, and then we need implementation. Here it says a person who fails to comply with a legal instrument. This is under Section 5. Will mens rea have to be proved, or will this be a strict liability offense? Now, subsection 2. This has to do with service of the legal instrument. I believe here Articles 56 and 57 will apply, so service here will have to meet the requirement on service under the mainland law. So I just want to confirm I'm getting subsections 1 and 2 right. Who will take the question, please? Secretary for Justice. Ms. Khan is right. So we're talking about an objective fact. It's about whether someone has complied with the legal instrument. If someone did not comply with the instrument, that's an offense. But we also have to look at subsection 2 as well. So when someone does not comply with the legal instrument, that appears to be an offense. But then we also have to look at subsection 2. If there is a reasonable excuse, then the person should be fined. Now, on service, as I said at the earlier session, Ms. Khan is right. In this case, we're talking about the mainland's criminal procedure law. Now, we can look at section 9. Dates, signature, etc. Those matters fall under section 9. But overall, Ms. Khan is right. Mrs. Regina Ip. My question has to do with subsection 1 under section 5. What if it's a delivery failure? Say the person is out of town, so that person will never be not complying with the legal instrument. Secretary for Security. Now when it's a delivery failure, this provision will not apply. What if you get the wrong address? What if this person can prove that the instrument was delivered to the wrong address, or this person is not in town when the document is delivered? Will that count as a reasonable excuse? So if it's a delivery failure, this person will have never received it, and then that would be a reasonable excuse what that person will have to show. That's the case. Mr. Holden Chow. I have a follow-up question on my earlier point. Now, I'm looking at sections 5 and 8. I thank the DOJ for explaining the difference in the drafting, and that's the phrase about proof beyond reasonable doubt. Now, my understanding is that Section 8 has to do with a much more serious offense, which is disclosing an ongoing investigation. But I want to make sure I'm getting this right. The prosecution will still have to prove the defendant's offense, and then you have Section 8 dealing with a more serious offense. My impression is that under Section 8, the defendant will have to adduce evidence. My question is, for Sections 8 and Section 5, we still have to stick to the standard of beyond reasonable doubt. I'm asking this question for a reason. At common law, in a criminal trial, conviction rests on the standard of proof beyond reasonable doubt. So it doesn't matter where the onus rests. I just want to make sure we're still sticking to this standard, proof beyond reasonable doubt. Mr. Ivan Leung. Thank you, Chairman. I thank Mr. Chow for his follow-up question. Mr. Chow is right. In a criminal trial, we have the presumption of innocence. That's why the prosecution has the onus of proof, and the standard of proof is beyond reasonable doubt. For each offense, we look at the elements. We also look at the defense. Those elements, those defenses vary from one ordinance to the next. Now let's come back to sections 5 and 8. The difference lies in the defense. Under section 5, the defendant will simply have the evidential burden, whereas under section 8, the defendant will also have the persuasive burden, but the standard will be the balance of probabilities for the defendant instead of beyond reasonable doubt. Those standards actually are also applied elsewhere in criminal law. The court has laid down different principles for the standard of proof required from the defendant. Sometimes the defendant has the evidential burden. At other times, the defendant has a persuasive burden. I don't want to go into the specifics, but broadly speaking, first, we have to look at the elements of the offense. There may be certain points that do not require proof from the prosecution. Say you have an offense that is very broad. It may cover brazen or blatant cases of fault. Now, on failure to comply with a legal instrument, there are different possibilities. Say delivery has happened, but the person is out of town. This person has never received the instrument. At the panel discussion, the secretary has also made this point. Say someone's computer broke down. they cannot provide the information requested in the instrument. There can be many possibilities. That's why under Section 5, the defendant's responsibility is simply to provide the evidence. But then under Section 8, it's a different story. Because under Section 8, it's about disclosing information about investigation under Article 55 of the NSL. Here, under Section 8, the action itself is obviously criminal in nature. That's why the defendant will have to bear the persuasive burden to the standard of balance of probabilities under Section 8, and that's to raise a reasonable excuse or invoke lawful authority. Mr. Lai Dong Kwok. I have a question about service. What does service entail in this context? The government just said we will have to meet the requirements of the mainland's law. We don't know if the mainland's requirement is the same as that in Hong Kong. So how should the average person make sense of the phrase service? If a legal instrument is not served, the offense under Section 5 will not apply. So we will need further clarity on what we mean by service here. When will you meet the threshold of service in this context? Mr. Ivan Leung. As far as we understand it, now, service in this context will be subject to the criminal procedure law of the PRC. Under that law, there is judicial interpretation over the minute detail. From what I understand, there are different means of service, and that's similar to what we have in Hong Kong. Service can be personal service, meaning you give the instrument to the other person in person, or you can simply send the instrument to an address. The mainland also has similar requirements, but I cannot tell at this moment that the mainland's requirements are exactly the same as those in Hong Kong. But what we think is it's a situation where Article 55 of the NSL is invoked to deal with the 4 kinds of national security offenses, and this will be a serious matter. In this case, officers of the OSNS will resort to ways such as personal service. This is the most certain way of service, and that also shows the gravity of the matter. But as for the nitty-gritty, we will have to look at the actual circumstances when the case comes up. But Mr. Lai is right. Service needs to be established first. Otherwise, you cannot establish compliance, and there is no offense. So we have to look at the offense and the defense holistically. Chairman, I want to make one comment. As my colleague said, whether service is effective will hinge on the PRC's criminal procedure law. I'm not a trained mainland lawyer, but I want to say this is a rigorous process too. Now, I'm looking at Article 107, and this is just the first sentence. Now, when you serve a summons or other instruments, you have to serve the instrument on the person or hand it to an adult family member or someone at the office of this person. So this is in line with common sense. Now, I'm not a trained mainland lawyer, but I'm looking at the provision itself. There are rigorous requirements for service under the criminal procedure law of the PRC. You have to serve the instrument before you can say someone has failed to comply with that.
Mr. Tony Che. Someone who does not comply with the legal instrument would commit an offense. What happens if someone is not sure if the legal instrument is real or not, and they choose to remain silent? Do they have a right to do so? And because of their suspicion, they choose not to give any information or facilitation to the OSNS. Would that constitute a reasonable excuse or a defense? Secretary, a person may take action to verify the validity of the legal instrument. They may make a report to the police. Then that's a reasonable act. Dr. Lo Wai-kwok. Thank you, Chairman. A simple question. On the point about service, I think that people are familiar about how we serve documents or instruments in Hong Kong. I'd like to commend the Secretary for Justice. He just now read out the practice adopted on the mainland. Because the practice that we adopt in Hong Kong and the mainland may be different. Just now, the Secretary of Justice just read out the provisions under the criminal procedures laws of the mainland. That has alleviated our concern. I think that this is a very effective way to answer our questions. That's a comment. Please proceed. Thank you. Now we come to Section 6. In order to ensure that the person, individual, corporation would act in good faith in complying with or purportedly complying with the legal instrument without worrying about liability, that's why we have included the provision on immunity from civil liability. There are 3 sections. Subsection 1, a person is not civilly liable for an act done or admitted to be done by the person in good faith in complying with or purportedly complying with a legal instrument. Subsection 2 is about public servant. They are not civilly liable for an act done or admitted to be done by the civil or public servant in good faith in acting or purportedly acting under Section 3 or 4. I'd like to raise a point here. When we talked about compliance with legal instruments, we talked about purportedly comply with the legal instrument. We also put purportedly complying with the legal instrument here is to make sure that a person acting in good faith to comply with the legal instrument will not be civilly liable. A person may worry if they will be civilly liable if they act in compliance with the legal instrument and if their act is outside the scope of that instrument. That's why we have included this immunity. Subsection 3. Subsections 1 and 2 do not affect any liability of the government for the act or omission of a public servant. So under such circumstances, the government will still take up the civil liability. Questions? Mr. Holden Chow. Thank you, Chairman. I have one question. I'm not sure if my understanding is correct. So when a civil or public servant has to take a certain action to comply with the legal instrument, and if there is any civil liability arise, then they will not be held liable. So in other words, the public servant will not be liable, but the government will. Am I right? Say, for example, if the government asks the public servant to take certain action and accidents occur and someone claim damages from that public servant, then the government will take up the liability and pay compensation. Is my understanding correct? Your understanding is right. It's easier for us to explain about it with an example. If a public servant act in accordance with the direction of an OSNS to destroy a door, for example, if the public servant is held liable in their action, then they would perhaps not dare to do so. However, if a door is destroyed, then the owner of the apartment may suffer loss. And under Section 6, we say that the government will be held liable, but the public servant will not be. Mr. Kennedy Wong. Thank you. I have a question for the law drafting team of the DOJ. Under subsection 1, it says that a person is not civilly liable for an act done, so on and so forth. Under subsection 2, it says a public servant is not civilly liable. I believe that a person should include public servant. So why do we have these two separate subsections? Thank you, Chairman. Thank you, Mr. Wong, for the question. The scope of subsection 1 and 2 is very different. Subsection 1 is about compliance with legal instrument. A legal instrument may be issued to anyone. So subsection 1 should cover a person or any person. That may include public servant, because public servant may also be served with a legal instrument. For subsection 2, we're talking about public servant acting under section 3 or 4. We have already scrutinized section 3 and 4. They're about how the public servant have to offer facilitation and assistance to the OSNS under special circumstances. So subsection 2 only apply to public servant. Section 3 or 4 may not entail legal instrument, so we're describing two separate scenarios. That's why we have to draft two different provisions. Mr. Yang Wen-kit. Thank you, Chairman. I'd like to follow up on subsection 1 under section 6. What happens if a legal instrument is issued by a scammer? Then the legal instrument would be false in itself. If a person act in good faith and compliance with the legal instrument, then will they still be held civilly liable? And if that person is a public servant, will they be exempted from the civil liability? Or will they be held liable? Secretary. Well, with this example, the person truly believed that the legal instrument is real and they didn't know that they were being deceived, then they would enjoy the immunity from civil liability. However, if the person knows that the legal instrument is false, then they will not be immune because they are not acting in good faith. Chairman, a follow-up question. So does it apply to just public servant or any person? That apply to any person, including public servant. Mr. Tommy Che. Thank you, Chairman. Section 6, immunity from civil liability. Subsection 1, a person is not civilly liable for an act done or omitted to be done by the person in good faith and complying with or purportedly complying with a legal instrument. Purportedly complying with.看來是遵從 in Chinese. 真誠地 in Chinese, English, in good faith here. In the Oxford Dictionary, purportedly means something purported to be true and it could be false. Under Section 7, on providing false or misleading information, under subsection 1, if a person in purported compliance with a legal instrument gives any testimony or makes any statement, so on and so forth. My question is, how should we understand this term purportedly complying with? And what does it mean by an act done or omitted to be done by the person in good faith? Can these two circumstances coexist? Should we only immune someone from civil liability when they act in good faith, when in complying with a legal instrument that is true? Mr. Lang. Thank you for the question. He asked why we include purportedly complying with in the provision. We use the same way of drafting the provision in immunity from civil liability provisions in other ordinances. Sometimes we immune a public officer from civil liability when they carry out their duty as a public officer. We have included the references and ordinances that we have made reference to in the brief. Any person or any public servant, when they comply with the legal instrument or assist the OSNS in carrying out certain duties, may, because of negligence, commit civil offenses or make certain mistakes. And they may, because of negligence, carry out duties outside of the power conferred onto them. If we don't give them immunity, then a person or a public servant may be too worried to carry out their duties in assisting the OSNS to their best ability. That's why we include this immunity from civil liability. And we have to include this word purportedly as a result. Mr. Chen asked if the concept of good faith contradicts with the word purportedly. We don't think so. A person may make mistakes by doing an act that is outside of the scope of legal instrument. That person may still be acting in good faith, although they may have made a mistake. We think that we should immune that person from civil liability in such a case. However, if a person acts recklessly, if they are not acting in good faith and complying with a legal instrument, in that case, they would be acting in bad faith. So the good faith standard is one that we adopt very often.
Ms. Carmen Khan. My question has to do with Section 6, Subsection 2. So we have to read this in conjunction with Sections 3 and 4. Mr. Ivan Leung from the DOJ has already explained the idea that you want Subsection 2 because you want civil servants to support the work of the OSNS under Sections 3 and 4. Now here we see an act done or omitted to be done in good faith. In this case, civil immunity applies. Now, our Legisl brief has also cited other ordinances in Hong Kong where such civil immunity also applies. So my question is, say under the Securities and Futures Ordinance, the civil immunity is spelled out in greater detail. So it doesn't matter if it's contract, tort, equity, or defamation. That's written under the SFO. But no such elaboration is found under this subsidiary legislation. So are we talking about immunity from all civil liability across the board? Now I turn to my second question, and this has to do with in good faith. There are precedents about what good faith means, so we don't have to define that. So I just want to make sure that I'm getting this right. Who will take the question, please? Mr. Wallace. So the first question, whether we should elaborate on civil liability. Now let's look at newer ordinance, CAP 652, 628. Under those two ordinances, we adopted a more generic kind of immunity. So we simply say this person will be immune from civil liability, and then we go on to elaborate whether it's tort, whether it's contract. So the subsequent part is simply there to elaborate, to clarify the point, to avoid doubt. Actually, it's good enough to say that someone is not civilly liable. That's why under the new ordinances, we no longer elaborate the point. Now, on the point about in good faith, Mr. Ivan Leung can take that question. So for civil immunity clauses, the phrase in good faith comes up very often. This is not a novel concept in law. Many precedents also feature this concept in good faith. So when we say someone acts in good faith, we're saying someone is not acting recklessly or has extraneous purposes, meaning they have some kind of ulterior motives. Say someone may have a hidden agenda. Someone may have a hidden agenda instead of actually supporting the OSNS. Thank you, Mr. Jeffrey Lam. Now, I want to raise a point that's top of mind for business people. People in business signed confidentiality agreements or non-disclosure agreements all the time. So my question is, say you have a company in the normal course of business. In what circumstances will such a business be asked to give support to the OSNS with all those NDAs or confidentiality agreements in place? So what will that mean for NDAs and confidentiality agreements in place? This is a point close to the heart of businesses, local and non-local. So can the Secretary for Justice tell us how this will work? So we will first have to look at the requirements under a specific legal instrument. If that legal instrument asks a business to disclose information, then in principle, that company will have to follow the requirement. Now, immunity applies in such cases because in contract or elsewhere, there may be a confidentiality requirement. Now here, in this case, we're talking about serious matters. We're talking about an Article 55 scenario when national security is endangered. Law enforcement requires disclosure of information. So we want to put the minds of a company at ease. That's why we have this provision granting civil immunity. There are also laws on breach of confidence. When you have immunity, people won't have to worry about those laws. The most important thing here is for the party to comply with the legal instrument. Thank you. Now it's my turn. My question has to do with the phrase in good faith, a question raised by Ms. Carmen Khan. But I want to clarify something about this concept. This phrase, in good faith, has also come up often in court judgments. This phrase comes up under the SFO, Section 20 under the SFO, for example. Mr. Ivan Leung also brought up other ordinances. Those ordinances have immunity provisions. The person involved should act in good faith before they can invoke such immunity. Now, given the prevalence of this phrase in good faith across ordinances, so in the context of this subsidiary legislation, when we say good faith, does good faith mean the same thing as in other ordinances? Will people be expected to meet a higher threshold before they can claim they act in good faith? Secretary, we're talking about the same thing. The phrase good faith is found across common law. It's a very straightforward concept. So to use the Secretary's example, say, I'm asked to comply with a legal instrument. I am asked to break open the door. Now, say when this person is simply settling a personal score with the other person and damages the door, someone is using compliance with the legal instrument as an excuse to take out frustration on the other person. That will not be acting in good faith. Acting in good faith simply means acting with honesty, the absence of ill will, the absence of an ulterior motive. So that's something that's well established in common sense. I don't think the average person would struggle to tell what acting with honesty or in good faith means. Mr. Chen Xiu-hong. I have a question about Section 6, Subsection 1. So, when we say a person, we have covered that point. We understand what it means. But then a legal instrument may require an organization to provide information. Now, of course, someone may be acting on behalf of that organization. So, a person here, does that also include an organization? Law officer under Cap 1 Interpretation and General Clauses Ordinance, a person in law also covers an organization. Deputy Secretary. Now, Section 7. Now, Article 59 of the NSL states that when the OSNS is acting on a matter under Article 55, the person has to give testimony truthfully. So that's why under Section 7 there is an offense for providing false information. There are two subsections. So subsection 1, someone in purported compliance with the legal instrument gives any testimony or makes any statement or provides any information, and this person knows the testimony, statement, or information or document is false or misleading. Or 2, is reckless as to the testimony, statement, information, or document is false or misleading in a material particular, this person commits an offense. And this offense is punishable on conviction with a fine up to $500,000 and 7 years in jail. And then a witness may be asked to testify in the mainland under the legal instrument, and then subsequently we find out this person gave false evidence in the mainland. That's why we have subsection 2. Here, the provision grants extraterritorial effect, meaning someone who gives false evidence in the mainland then subsequently returns to Hong Kong, this person will still be considered to have committed an offense, so that penalty of $500,000 and 7 years in jail will still apply. Mr. Lai Tong Kwok. I want to check if I'm getting this right. Section 7, you have A and B under subsection 1. The phrase material particular comes up under both A and B. So when someone gives testimony or shares a document, the information that is flawed has to be a material particular. A minor typo will not be targeted by this provision. Who will take the question, please? Mr. Ivan Leung. I thank Mr. Lai for his question. Mr. Lai is right. Now, on providing false information, first you need mens rea. This person has to know there's a mistake or it's reckless. And the error has to be in a material particular. Again, this phrase comes up often in law. Say, the requirement has to do with the testimony, and the person is asked to fill in their age. Maybe the age of that person is immaterial. In that case, someone struggles to recall their actual age for a senior. They fill out their age, but the age turns out to be false. In that case, it's not false information in a material particular. Ms. Carmen Khan. Just then, Mr. Tommy Chen raised a point about the term purportedly. Now, but here the Chinese is different. It reads 冲着. So by that Chinese phrase, are we saying that someone is simply pretending to comply? The English phrase is still purported. So are we saying under subsection 1 of section 7, someone is pretending to comply? So how can we make that clear? Now I turn to subsection 1A and B. So A, we're talking about actual knowledge. It's not constructive knowledge. Is that what we mean by knows? Now at the meeting of the joint panel, I also raised this point. You have Article 55 under the NSL. When that article is invoked, a person may be asked to assist with investigation outside Hong Kong. That person may be asked to give testimony or supply information. We may subsequently find out that this person has given false information. We want to catch that person in that case. That's why we have subsection 2. So we're not restricting the scope to the mainland under subsection 2. That's why we have extraterritorial effect, and this is the only provision with extraterritorial effect. Is that the case? Mr. Wallace, I will take the first question. Purportedly, Ms. Carmen Khan is correct. In purported compliance here, in Chinese, we use the term 冲着 because we want to stress that this person is pretending to comply with the legal instrument. That's why, in that context, the Chinese phrase is 冲着. Now, as for the other question, my colleagues can take those questions. Mr. Ivan Leung. On Ms. Carmen Khan's second question, indeed, actual knowledge instead of constructive knowledge is required. Now, the third question, it's about the scope of the extraterritorial effect. As we have explained in the paper, someone may be assisting with the investigation of the OSNS in the mainland, and there they give false evidence. If we simply say the effect applies only to the mainland, we will be too restrictive in our provisions. In our own SNSO, we do not say that the extraterritorial effect of a clause only applies to the mainland. So to keep things simple, we simply say any act outside the HKSAR. This is not to say that the mainland law enforcement will enforce the law outside the mainland. Everything has to be done in accordance with the law.
It's my turn. I wanted to ask about the term no as well, but Ms. Carmen Khan has already put the question. I have another one. Just now, the administration said that no refers to actual factual knowledge. Does it include inferred knowledge? I'm not sure if my translation is correct. Chairman, we have to prove that the defendant actually know that the testimony or statement is false or misleading. Chairman just now talked about inference, inferred knowledge. That's not what we have to prove. We have to rely on, say, direct evidence to prove whether a defendant know. Sometimes we have to rely on environmental evidence or circumstantial evidence. But that has to be irresistible inference before we can prove that beyond reasonable doubt. So there has to be circumstantial evidence before we can prove the defendant know that the testimony or statement is false or misleading to meet the standard of beyond reasonable doubt. Let me supplement. We have constructive knowledge, factual knowledge, inferred knowledge. To put it simply, how can we prove that someone knows that the testimony is false or misleading? We can only rely on, say, circumstantial evidence, for example. If we refer to subsection B, there is an element of recklessness. We may not be able to rely on circumstantial evidence to show that the person actually know. However, if you willfully disregard the fact that the testimony or statement is false or misleading, then that's a willful blindness, and that will constitute an offense. The concept is similar to that of inferred knowledge, but we have included two elements here. So you either actually know or you are reckless as to whether the statement is false or not. The answer is very clear. Deputy Secretary, please proceed. Thank you. Now we've come to Section 8. To make sure that OSNS work is kept confidential, that's why we have included Section 8. The offense of disclosing measures being taken or investigation being conducted by OSNS. If a person discloses the measures or investigation, then they commit an offense. There are two subsections to it. One, if a person knows or suspects that the OSNS is taking certain measures for ascertaining whether a circumstance mentioned in Article 55 of the Hong Kong National Security Law exists, that can bring us to Section 3. Or through its exercising jurisdiction pursuant to Article 55 of the Hong Kong National Security Law on conducting an investigation and without reasonable excuse or lawful authority discloses to any other person or any information relating to the measures or investigation, the person commits an offense. And because this disclosure has to do with measures being taken or investigation being conducted by OSNS in relation to Article 55, this is a very serious offense. That's why we propose a fine of $500,000 and imprisonment for 7 years. Under subsection 2, it says, however, if at the time of the disclosure the OSNS has made public the information, then subsection 1 does not apply to the information. Thank you. The speaker is off mic. Reverend Peter Kun. Thank you, Chairman. It's easy for us to understand the concept no, but how does a person suspect that an OSNS is taking measures to ascertain circumstance mentioned in Article 55? Can you give us some examples? Secretary. Thank you. Say if an OSNS gives you a legal instrument saying that they are investigating a certain person under Article 55, then you would know for sure that OSNS is investigating. But sometimes OSNS may ask you for information. They may not explicitly tell you that they're investigating a case. Then under that circumstance, then you have reasonable suspicion that OSNS is investigating a case under Article 55. If you disclose the measures of investigation still, then you commit an offense. We do provide for a reasonable excuse for this offense. To explain to the court. We have to look at the circumstances of the case, however. Reverend Peter Kun. Any follow-up question? Mr. Chan Xiu-Hong. Thank you, Chairman. Subsection 1, A, B, say that if a person knows or suspects that the OSNS is taking certain measures or is investigating a case, then they commit an offense if they disclose them. Sometimes OSNS may ask someone to enter the premises, and that person may possess the keys to the premise. That's why they were asked to open the door. And that person, if they don't have the authority to open the door, they may have to seek approval from the supervisor. When that person is asked to open the door, they would know that OSNS is taking action. And if they disclose the action of, say, opening the door, would they commit an offense? If they have to seek assistance from the third party in order to complete the action requested by the OSNS, will they commit an offense? Or should that person ask the OSNS to give them permission to seek approval from their supervisor in order to open the door, for example? How do we deal with such a circumstance? Secretary, it's hard for me to give you an answer across the board. We have to look at the circumstance of the case. Say, for example, if I'm asked to open a door, then I wouldn't have to, say, tell someone to open the door because OSNS is asking them to do so. So is it necessary for you to tell someone that you open the door at the request of OSNS? Say if you are an employee, you have to open a chest and you have to seek permission from your supervisor to do so, then that may constitute a reasonable excuse. If you have to convince the boss to open the chest, then you may have to disclose the reasons behind that, and that may constitute a reasonable excuse. Secretary for Justice, if you receive a request from the OSNS to take certain action, you have to seek approval from the third party, then you should obtain approval from the OSNS to do so. Mr. Chan, I believe that the answer is very clear. Mr. Holden Chow, thank you. I have a scenario. It says that if a person knows or suspects that OSNS is investigating a case, then we should not disclose the information. If I suspect that OSNS is investigating a person, if I disclose it, then I commit an offense. What happens if the OSNS is not actually investigating person A? If I disclose to other people that OSNS is investigating into a person under Article 55 when the OSNS is in fact not doing so, would I commit an offense? This may be an imaginary scenario. What if I tell everyone about the fact that I suspect OSNS is investigating a person when that's not the truth? That may have to do with Section 13, offense of falsely pretending to be or be able to influence staff of OSNS. Secretary, who will take the question? Mr. Lan. Thank you, Mr. Chow, for the question. In this scenario, that person will not commit an offense under Section 8. there is an element of act here and an element of mens rea. Under Prevention of Bribery Ordinance, there is an offense of disclosing investigation conducted by the ICAC, and recently, the Court of Final Appeal explained about the relevant provisions under the Prevention of Bribery Ordinance. There is an elements of act and elements of mens rea for the offense. Well, first of all, there has to be an investigation in the first place. Under the Prevention of Bribery Ordinance, only when an investigation is conducted under Part 2 of the ordinance has taken place, then the person disclosing the investigation would commit an offense. If there is no investigation, then no one would commit an offense. And when there is actually such an investigation, we also have to substantiate that the person actually know that the OSNS is investigating. Eventually, if we found out that the OSNS is not taking measures or conducting investigation, then that person would not commit an offense under Section 8. If someone intentionally trying to spark fear in the community by spreading false information, that will have to be dealt with by way of invoking other legislation. Deputy Chairman, that's exactly what I was thinking of. Because spreading false rumor may affect other people. It says that the case cannot be dealt with under Section 8, but I think that it's important for us to have ways to deal with such a risk. Thank you. Secretary for Justice. If someone intentionally say that he or she was being investigated by the OSNS, then that person would be sued with defamation. We definitely have laws to invoke to protect the reputation of a person. If you need a solicitor to charge the person for defamation, please reach out to me. Thank you. Mr. Kennedy Wong. Subsection 1B talks about reasonable excuse or lawful authority. Does that cover consulting seeking legal advice? We may have to seek legal advice from the mainland. Is that covered under subsection 1B? Secretary. This comes back to the point of reasonableness. If you are just filibustering, then that would not be reasonable. We have to look at the circumstances. Deputy Secretary, please proceed. Thank you. Section 9. It has to do with legal instruments. It's evidentiary provisions. There are two subsections. Subsection 1, if a document purports to be a legal instrument or purports to be a copy of a legal instrument certified by the OSNS or a staff member of the OSNS, then in any proceedings, the document is admissible in evidence without further proof on its production. Subsection 2, unless the contrary is proved, the document is presumed to be a legal instrument or a copy of a legal instrument certified by the OSNS or a staff member of the OSNS, and is evidence of any of the following facts, if applicable, the date of issue or certification of the document or the date of service of the document on the person concerned. If the legal instrument is admissible as evidence, then that will speed up the production of proof and do away with the needs of calling witness. This saves us time and streamline the procedures.
Questions, Mr. Jeffrey Lam. Hong Kong people think we have a robust legal system. We also respect our law enforcement officers. Many people don't even get to see a legal instrument once in their life, let alone an instrument issued by the OSNS. Recent media reports show that some people exploit misinformation to mislead people into doing wrong things. Now, there are people acting with ill will. They show instruments that they claim to be certified copies of legal instruments. And then there are simple-minded people. They have never come across legal instruments. They have never come into contact with law enforcement. They get a call from someone who claims to be the police, someone who claims to be national security officers, and then they panic. When that happens, how do we help the public to tell forged instruments from real ones? Secretary for Security, I will attempt an answer. If needed, my colleagues from the DOJ can supplement my response. So the question here is about the legal process. During a trial, we will not need strict proof. Now, when someone receives something that is described as an legal instrument from the OSNS, or when someone claims to be someone from the OSNS, if you have suspicions, the reasonable thing to do is to call the police, go to the police to verify the matter. But the other person may warn the unsuspecting victim against telling the police. They may claim to be an officer and the matter is confidential. If I'm told by someone not to approach the police, I will get even more suspicious. Mr. Holden Chow. I want to confirm I'm getting this right. So, something that is purportedly a legal instrument. So if I see what looks like a formal document with chops, with stamps, will that count as something that is purportedly a legal instrument, something that is presumed to be a legal instrument? So I just want to make sure I'm getting this right. Mr. Ivan Leung. Evidentiary provisions like Section 9 here are common. A document that purports to be a legal instrument is admissible in court. We don't have to call the person who issues the document as a witness. So something that appears to be a legal instrument is good enough. So we look out for chops on that instrument. The instrument also says this instrument is issued under a certain regulation or law. Say, I can imagine an instrument from the OSNS will have a sentence saying that this instrument is issued in accordance with Article 55 of the NSL and a certain provision of the Criminal Procedure Law of the PRC. But we want to stress that we're talking about a document that purports to be a legal instrument. But if someone questions the authenticity of the instrument, and then that's when subsection 2 kicks in, that is, when the contrary is proved. Mr. Tommy Chan. I have the same question. For someone uninitiated in law, when we see phrases like purports to be, we are left wondering what it means. So we just heard the explanation. Do we have alternatives to the words 可能是 or purports to be, so that someone without a legal background will have an easier time grasping what is meant here? Thank you. I thank Mr. Cheng for his question. This phrase, purports to be or 可能是 in Chinese, this is an evidentiary provision. When a document purports to be a legal instrument, we can take that as evidence. I think the current drafting reflects our meaning. Something that purports to be a legal instrument is good enough for our purpose, and that reflects the policy intent. Thank you. Deputy Secretary, let's move on to Section 10. Thank you. Section 10 states that the government is to provide assistance for the OSNS's performance of its mandate. Now, we just talked about Part 3. Part 3 is about the OSNS handling cases concerning national security offenses. We just covered some detailed requirements on how the HKSAR government can give support. Now, in other areas, government departments, agencies, and public servants should also respond to the request of the OSNS by providing all necessary and reasonable assistance, facilitation, support, backing, and protection in a timely way. We're setting out some examples to show people what we mean. So we have set out 3 examples. 1, priority in entry into and departure from the HKSAR. 2, conveyances for staff of the OSNS and access to places under the control of public servants. And 3, when a permit is needed to enter a certain place, we allow those people in, we give conveyances to those people so that those people can access the premises. Questions? Referent Peter Kun. Here it says priority in entry into or departure from the HKSAR. What do we mean by that? Secretary for Security. Say when someone is on urgent business, then those officers will get priority access when they are at the immigration or departure counter. They won't have to queue. Mr. Chen Xiu-hong. So Section 10 is about providing necessary and reasonable assistance facilitation for the OSNS. I see the phrase including here, and then you have items A, B, and C. They have to do with entering Hong Kong or leaving Hong Kong or entering premises for business. I think including is not exhaustive in nature. I can think of a situation. You have OSNS officers arriving on scene. They may need devices or equipment to enter the premises. Here I see the provisions referring to entering the premises. But those OSNS may also have to borrow certain devices or equipment to enter premises. So that's also included. Am I getting that right? Secretary for Security? Yes. We're simply giving some examples. So these examples are non-exhaustive. Mr. Stanley Ng. Now my follow-up question is that I know this is about listing some examples as part of their subsidiary example, but will that create the false impression that we're only including these 3 examples to the exclusion of other forms of support? Other kinds of support may also be warranted. Why create such possible false impressions? Law officer. As our colleagues have stated clearly, we're only listing some examples. Our policy intent is to give some details to facilitate the law's implementation. So the overall principle is to give all necessary and reasonable assistance, facilitation, support, backing, and protection. So examples are as follows. We set out 3 kinds of examples. Those examples fit the bill. We are not providing an exhaustive list. There can be other forms of support, facilitation, backing, and protection not set out among these examples. Ms. Carmen Khan. Now, I see subject to Part 3 under Section 10. I'm looking at Part 3, Sections 3 and 4. Both those sections have to do with public servants. And here, Section 10 also refers to public servants. Sections 3 and 4 under Part 3 have to do with the investigation. And then Part 4, we are talking about beyond investigation. Article 61 of the NSL says that when the OSNS performs its duties under the NSL in safeguarding national security, the SCR government has to give support and facilitation. So I want to check my understanding. Sections 3 and 4 are under Part 3. When the OSNS performs duties outside the scope of Sections 3 and 4, we're spelling out under Section 10 what is required of public servants. I just want to check my understanding is correct. This is correct. Since we're talking about civil servants, now we have the Civil Service Code for those who fail to cooperate. Now, Section 3 has to do with investigation as part of an Article 55 situation. Mr. Gary Chan. Can I get the government to clarify subsections B and C under Section 10? When we say any place and any premises, now we're talking about places where duties are performed, such as government offices. But what if we're talking about government premises, such as civil servants clubs or staff quarters? Are those places covered under the 2 subsections? Yes, they are covered. Those are government premises. Say, it's a vehicle, government vehicle. But we have to be reasonable. So we won't be covering the home of a civil servant. Legal advisor. Thank you, Chairman. I have a question that is related to Mr. Gary Chan's question. We're looking at subsections B and C. Those provisions say we should let in OSNS officers. We should let them into a place which the department, agency, or public servant is in charge of. So can we get the government to elaborate on whether these places are fully controlled, fully owned by the government? Do we have any specific examples? Can the government share some examples for members' reference? So can we get some examples of the premises and places involved? Ms. Stephanie Sill. Now, when we say a place of which the government is in charge, we're talking about the places where civil servants and people have access to. There's a CFA ruling. Now, Cap 172 has to do with the place of public entertainment. That ruling explains what is meant by a place where the government has control over access to the place. Say you have a government agency or public servant who can deny access to a place. when that place is involved under Section 10, subsection 10b, then they have to let in an OSNS officer.
Deputy Secretary, please hold. Please proceed. Thank you. Chairman, Section 11. Under Article 60 of the National Security Law, the acts performed in the course of duty by the OSNS shall not be subject to the jurisdiction of the Hong Kong SAR. The staff and the conveyance of the OSNS will not be subject to the jurisdiction of the Hong Kong SAR either when they are carrying out their mandate. So we provide for this evidentiary provisions relating to the identification documents, etc., created or issued by OSNS. There are two subsections to this section. 1. If a document purports to be an identification document or a document of certification created or issued by the OSNS in respect of any of the following matters, then in any proceedings the document is admissible in evidence without further proof on its production. A. The identity of a staff member of the OSNS. B. The fact that the OSNS owns or possesses a conveyance. C. The fact that the OSNS or a staff member of the OSNS does not enact for performing a duty in accordance with the Hong Kong National Security Law. Subsection 2. It talks about how we admit the document as evidence. Unless the contrary is proved, the document is presumed to be created or issued by the OSNS and is evidence of a matter mentioned in subsection 1A, B, or C, including the identity of a staff member of the OSNS, the fact that the OSNS owns or possesses a conveyance, or that the fact that the OSNS or staff member of the OSNS doesn't act for performing a duty in accordance with the national security law. Our meeting was supposed to end at 4 p.m. I hope that we can complete the scrutiny of the bill as soon as possible. So I propose a 15-minute break at 4 p.m. and at 4:15 p.m. we will start a third meeting. Any objection? A 10-minute break? Let's do a 15-minute break. Any objections? The administration, should we go for a third meeting today? I don't think that the third one will last 2 hours. We are willing to cooperate. Questions? Mr. Kennedy Wong. Thank you. Section 11. It's about evidence. When I was at school, I learned that evidence can either be true or false. However, here it says that if a document purports to be a document, so I'd like to know more about the reason why you use this word. Second, I have a suggestion. I don't think anyone here have seen any legal instruments issued by the OSNS. I hope that the administration will work with the OSNS in educating the public about this. Say if a conveyance is being intercepted and stopped and they produce a document that purports to be an identity card of a staff member of the OSNS, then the legal officers or the security guards have to let them go. So how can we enhance public education and publicity in this regard? Secretary, thank you. There are pros and cons to such publicity and education. If we teach people how to identify the staff cards of OSNS, we may teach also the scammers and how to falsify this information. If you have any doubts, just call the police. Any follow-up question? My first question was about the word purports. I hope that the drafting team will explain why they use this word. Mr. Lang. Thank you, Mr. Wong, for the question. The reason why we include this word purport is the same as why we include the same word in Section 9. That is, if the document appears to be a legal instrument or identification document issued by the OSNS, then it can be admissible in evidence without further proof on its production to the court. By this, we don't have to call a witness to prove the authenticity of the document. For the sake of fairness, we include subsection 2. We have also made reference to the garrison law in relation to the identification document requirement. Regarding Mr. Wong's suggestions on publicity and education, please consider it. Mr. Jeffrey Lam. Thank you, Chairman. I have some simple questions. I hope that by putting this question, we can alleviate people's concern. According to Section 12A, if a person willfully resists or obstructs, we haven't come to that section yet. We're at Section 11. My apologies. I will put my question later on. Any other question? If not, Deputy Secretary, please proceed. Thank you, Chairman. Now we've come to Section 12. Article 61 of the National Security Law states that the relevant departments of the government shall provide necessary facilitation and support to the OSNS and stop any act obstructing the performance of such mandate. So we provide for offense of resisting or obstructing OSNS or staff member of OSNS in performance of duty, etc. If a person willfully resists or obstructs the OSNS or a staff member of the OSNS in the performance of a duty in accordance with the Hong Kong National Security Law, or willfully assaults a staff member of the OSNS who is so performing a duty, or willfully resists or obstructs any other person assisting the OSNS or staff member of the OSNS in so performing a duty, or willfully assaults a person who is providing such assistance, then the person commits an offense and is liable on a conviction on indictment to a fine of $200,000 and to imprisonment of 3 years. We have made reference to other local legislation on resisting or obstructing the due execution of public officer. We have made reference to the offense against the persons, the summary offense ordinance, the police force ordinance, and the offenses relating to resisting or obstructing public officer. Mr. Jeffrey Lam, I will not repeat what I just said. I will go straight to my questions. According to Section 12A, if a person willfully resists or obstructs the OSNS or a staff member of the OSNS in the performance of duty, then commits an offense. B, if they willfully resist or obstructs any other person in assisting the OSNS in performing the duty, they also commit an offense. We have a lot of telescams, online scams these days. People's awareness against these deception have enhanced. Very few people have the opportunity to come across identification documents of OSNS. If people are afraid of falling victim to a scam, that's why they don't comply with the OSNS, will they commit an offense. By any other person, who are we referring to here? According to 12A, if a person willfully resists or obstructs the OSNS in the performance of duty in accordance with the Hong Kong National Security Law, can you explain what constitutes willfully resist or obstruct? It may be easy for us to tell if a person actually does a physical act, but what if a person makes a face of contempt? Would that constitute resistance or obstruction? Can you explain more clearly what they mean? I don't want people fall victim to the law inadvertently. Mr. Leung. Thank you, Mr. Leung, for the question. By assisting, we mean any person, because any person could assist the OSNS in the performance of their duty. We have made reference to the offense against the person, Ordinance Section 36, about obstructing the due execution of a police officer. It also covers resisting or obstructing other person in assisting police officer in executing their duty. Let me give you an example. A person may be helping a police officer in subduing a criminal, and if you obstruct such an act, then you may commit an offense. Second question, on what constitutes resistance or obstruction? These two words are common in the laws of Hong Kong. If someone proactively take an action to resist, say for example arrest, then that person may commit an offense. But obstruction, we have some authoritative case law. There's a case adjudicated by the CFA. By obstructing the police officer, there is an explanation. If a person adds to the difficulty of a police officer's carrying out of the duty, then that may constitute obstruction. But that does not cover minor inconvenience or extra efforts to be put by the relevant police officers. As to whether a obstruction is constituted, we have to look at the extent and the act that is done by the defendant or the police officer. We also have to look at what kind of impact is caused to the police officer by the defendant. When the law enforcement officer investigates the person, then the person may question why they were being asked questions or investigated. Would that constitute resistance or obstruction? Well, by seeking clarification from law enforcement officer, that would not constitute obstruction immediately. We have to look at the overall situation. If a person intentionally disregard what the OSNS staff says, then that may constitute obstruction. But if a person is merely suspicious and would like to clarify something, that may not constitute obstruction. Mr. Lai Tong-kok, Secretary of Justice. Thank you. The key is the word willfully. If a person is merely trying to verify the authenticity of a document, no reasonable court or a law enforcement officer would think that the person is trying to obstruct the performance of duty of a court or the law enforcement officer. Mr. Lai Tong-kok. Thank you. I'd like to focus on the word willfully. If a person does not resist or obstruct the person to carry out their duty intentionally, then they will not commit an offense. So I'd like to know if you also use the standard of willfully in other legislation. Under Section 12A, you said OSNS or a staff member of the OSNS. It seems that you separate them into two entities. What is the difference between the two? According to Section 12B, it says in sole performing of a duty. In Chinese, 语期. Why do you use the words "and so"? What happens if you remove the word "so"? Will that make a difference? 3 questions.
答咗頭兩
Mr. Ivan Leung, I will take the first 2 questions, and then my colleague, Ms. Wallenson, will take the 3rd question. First, willfully. So, willfully, this phrase is adopted in other ordinances involving obstruction of an officer. Now, in older ordinances, the Chinese text may read 故意, but now things have changed. The English version reads willfully. There are court judgments saying that willfully includes intention and also recklessness. But there is a subjective element. That's why a high threshold applies, since we're talking about obstruction. So we have to incorporate this subjective element. Now, on obstruction, willful obstruction, that's well established in case law. And this is also referring to a case where there is no reasonable excuse or lawful authority. Now, on the question of why we want to cover OSNS officers and other people, we want to be expansive in our coverage. We don't want to distinguish between specific officers of the OSNS in some cases, but in other cases, some duties can only be performed by specific OSNS officers, such as those investigating, arresting, or searching a place. So for completeness, we spell out all those points. Now, over to the drafting team, please be brief. Now, when we say so, we're saying performing duties under the NSL. That's why we put so there for simplicity's sake. So we'll take a 15-minute break. We will come back at 4:16. 16 past 4, we will start the 3rd meeting. Thank you.